Good morning. Can I welcome everyone to this, the 27th meeting of the Justice Committee in 2013. Can I ask everyone to switch off mobile phones and other electronic devices completely as they interfere with the broadcasting system, even when they're switched to silent. We received apologies from Margaret Mitchell. Item 1, decision on taking business in private. I'm asking you to agree to take items 3 and 5 in private. Item 3 is a review of evidence received to date in the Criminal Justice Bill at Stage 1. And item 5 is consideration of our work programme. We've already agreed to consider our draft Stage 1 report on tribunals bill in private. We'll take that under item 4. Are you agreed to take 3 and 5 in private? Thank you very much. Item 2, Criminal Justice Bill. It's our third evidence session. As with last week, we're only looking at part 1 of the bill on police powers to arrest, hold in custody and question suspects. And we have 2 panels of witnesses today. Now, welcome to meeting our first panel, Sheila McCall, Commissioner, Scottish Human Rights Commission, Professor James Chalmers and Professor Fiona Leverick from the University of Glasgow. I think you were in a starring role last week in other times. Can I thank you for your written submissions? And can I start right away with questions from members, please? John Finney.
Thank you, Convener. Morning, panel. It's a question for Ms McCall, please. I was very interested in the evidence, the written evidence submitted there, and the references to the CADR and the alterations made post-CADR, and the suggestion, and I'll use the quote here, the notion that some sort of rebalancing exercise requires to be carried out in the form of removal of other procedural safeguards, such as corroboration, which we're not covering, is mistaken, and the provisions abolishing corroboration without providing an adequate alternative safeguard are, of course, considerable concern to the Commission. Could you expand on that a bit, please?
Certainly. First of all, can I thank the committee for inviting the Commission to give evidence. One of the misunderstandings, as the Commission saw it, about the CADR decision was the notion that it gave suspects some added advantage and therefore there required to be some recalibration of the system in favour of victims and witnesses. In fact, what CADR did was bring Scotland into line with the minimum measures necessary to comply with Article 6 in terms of the right to legal assistance. So, from the Commission's perspective, there was a fundamental misconception about the starting point for the Carloway review and indeed the emergency legislation, that there needed to be some tipping the other way of the scales. The most obvious tipping of the scales has been in the proposal to abolish corroboration. But in the Commission's view, what's not been done in putting forward that proposal, as Lord Carloway did, as it now appears in the bill, is there hasn't been enough scrutiny of the implications of doing that without putting in another safeguard.
Can I say we're not doing corroboration today?
I understand that.
It's terribly hard to keep off that, I know. I know you're itching, but we can do this another day. Please try to keep to this, like this, arrest but not, what's the expression, team? Arrest but not officially...
That's not officially accused.
Not officially accused. That stuff, if you could. And can I just say to other panellists, I meant to say this at the beginning, that if you want to come in after somebody's been asked something, just indicate to me and I'll call you. Sorry. Yes.
I'm sorry, Convener. I felt it arose from the way Mr Finney framed his question, but I shall stick to part 1.
Don't be paying attention to the questions that they asked. Well, temperate, shall we say, yes.
Then looking at it from the perspective of part 1, broadly the Commission welcomes the general approach of that, which is in favour of a presumption of liberty. But we think there are a number of ways where the bill could be strengthened, because at the moment there's a danger, and it's one we highlighted at the time of CADR 2, there's a danger of creating grey areas where suspects may fall between the provisions for provision of legal assistance and so on. For example, where the police have grounds to arrest someone, but they choose not to do so and they choose to interview them in their house, that person will not get legal assistance. That's simply at the decision of the police and how they exercise their powers, rather than anything to do with that person's status and the consequence of our answering questions.
In relation to that, the Commission would encourage that there was a statutory definition for the reason of arrest, subsequent detention, and a statutory definition of who is a suspect. Would that address these issues, to your mind?
It would start to address those issues, but it wouldn't fully address those issues. What would fully address those issues would be, first of all, that when a suspect is initially cautioned, that he is told of his right to legal assistance and that is enshrined in the statute. And second of all, that where a suspect is not being taken to the police station but is to be questioned, that he is offered the opportunity of legal assistance and that is facilitated in the way it would be if he were at the police station.
Feel no. Right. John?
Thank you. And the dangers, were that not to be the case, then what does that taint the whole system?
The dangers, if that's not the case, are that at the initial point of interaction with the police, that suspects aren't made fully aware of their rights. There's a danger that where people are interviewed outside of the police station and they give incriminating answers, that may be in breach of their right to legal assistance in terms of Article 6 and may render the trial unfair. And there's also a flip side to it. In terms of being able to facilitate legal assistance outside the police station, it avoids unnecessary interference with people's private lives by having to take them to a police station where it needn't otherwise be necessary.
Tricky for, and you'll know this, John, is it not tricky for a police officer to know when the questioning has slipped into, I think you may have committed an offence, rather than, you know, it's slipped into that? You could start off by just asking questions about an incident, and then in the course of asking them, sort of become aware that they may be involved in another way which is criminal, or this reasonable suspicion is criminal. How would that, I'm thinking of the practicalities for the officer on the ground.
That's one of the reasons we say the statute should attempt to define what a suspect is, so that a policeman knows if that's the definition of a suspect and those are the people that need a caution and a right to legal assistance and all of those things that follow, is this person falling within that definition? And it gives clarity for both the suspect and the police officer. But I appreciate, Convener, what you're saying, and there is obviously a middle ground. For instance, a policeman comes upon a scene in the street, there are 10 people standing round and someone is dead on the floor. The policeman will say, what happened? And some people may answer that. At that stage, the policeman doesn't know if a crime's been committed at all, never mind whether any of these people are a suspect. So there's obviously a spectrum, but a statutory definition of what is a suspect and what then triggers these rights would assist police officers in that situation.
Do you have one?
I haven't got one written down in front of me. I'm not a parliamentary draftsman, obviously.
No, but I mean, this is where it's helpful to the committee in due course. If one proposes something, if someone provides, if the government doesn't, provides to members of the committee a proposed amendment, even to test it,
yes.
How useful it would be. Sandra, followed by Roderick.
Thank you very much, Convener. And good morning, everyone. Just following on from John's regarding the reformed powers of arrest. I think it was the Scottish Human Rights Commission that raised this particular one in the report, but obviously anyone else can come in that particular one. One of the concerns which was expressed in the report was that the marking of a person as a suspect could be given undue weight by the public and the media, obviously to the detriment of the suspect and subsequent criminal proceedings. I just wondered if you've got any thoughts on that. Obviously you put forward your thoughts and comments in the report. Could you perhaps expand on that?
Our view was, in relation to the situation where someone is released under what's going to be called investigative liberation, in other words, where they're essentially bailed to be brought back by the police at some later stage, our position was, in order to ensure proper respect for Article 8, for their rights to private life, which includes the right to reputation and so on, that given they're not officially accused of anything at that time, that they ought to have a right to anonymity and that ought to be built into the bill. One example of how that can go terribly wrong is in England in the Joanna Yates investigation, where the former teacher, who was her landlord, I think, Christopher Jeffries, was named as having been arrested.
We went through all that at the previous thing, so we're well aware of the whole tale and the trial by newspaper and so on.
That's the precise sort of example that one would seek to avoid, because while someone is not officially accused, there is obviously a lot of their private rights at stake, including their employment and all these sorts of things, and that ought to be protected at that stage.
Mm-hmm. I just wonder if anyone else had thoughts on that particular one.
So I'm just leaving.
No. Okay.
You're doing a Margaret Mitchell on me now. Yes, this is called doing a Margaret Mitchell, inviting other people. You're perfectly able, I'm sure. You want to say something, you're nodding, so on we go. Of course,
a small supplementary. I know other people may come in on the liberation aspect of it. whilst we're talking about the suspect, obviously concerns were raised last week and obviously were raised again regarding being detained and arrested. I mean, this obviously has a connection with that suspect. Do you think that the wording detained or arrest, are you concerned in regards to that?
I don't think the wording is the problem. It's a conceptual issue. It's what's actually happening that's the issue in terms of people's rights.
Right.
And one of the things that we would think assists greatly with the bill is if, right at the beginning, a principle for interpreting the provisions was to be inserted, setting out the presumption of liberty. So when officers go through and they think, should I arrest this person at all? Should I keep this person in custody? Should I put conditions on their liberation? All of that could be informed by the guiding principle of you should be in favour of liberty unless it's necessary to do otherwise. And we think there are perhaps a dozen or so sections of the bill that would be improved by having that principle at the start, as we've set out in our written response.
Thank you very much. Thank you, Chair.
You say anonymity, but perhaps if somebody is out, arrested, and without being officially suspected, whatever it is, and then there's on investigative terms, then that might be that they don't approach other people and so on as part of it because they could corrupt possible witnesses, intimidate. How could you have anonymity then if you've got to tell other people, this person's been in and we'll let them out because we're continuing to investigate? You'll have to tell some people, surely.
Well, the police will obviously know what those conditions are. And similar to the bail
But
situation
some members
from
of the public
court,
will have to know.
Well, I suppose it might be argued that if there's a complainer who's the direct victim of the alleged offence, that there may be some duty to protect them from potential harm. But what we've seen in terms of the police publicising someone's name in that situation is that it can be extremely problematic. So
Anonymity in a sense of the police not publicising it, but you're conceding that there would be circumstances where some people would have to be informed that somebody was out in investigative release. They would have to be.
There may be some circumstances because the police obviously have a positive duty to protect people from breaches of their Article 2 and Article 3 rights, right to life and right to be protected from cruel treatment and so on.
People in Roddy, followed by Elaine.
Morning, panel. Last week we heard a variety of views on the kind of concept of bringing detention and arrest together. Arrest is not defined in the bill. I referred various panellists last week to the question that Lord Carloway had recommended that arrest should be defined as meaning the restraining of the person and, when necessary, taking him or her to a police station. Chief Superintendent O'Connell described his understanding of arrest as that a person is no longer free to go about their lawful business or has not been advised that they're free to do so. That was generally considered to be, in many respects, just a kind of redefinition of the current position in relation to detention. I'd be grateful for the panelist view. I heard what Sheila McCall said earlier about the difficulties in kind of merging the two concepts without having a definition. Any thoughts on that?
I don't see any difficulty in merging the two concepts. In fact, I think it gives us a much more rational and sensible system than the one we have at the moment. One of the difficulties with the definition of arrest is that the existing law is actually quite unclear. I think you heard evidence the previous week from one witness who quoted Brenton and Brown's criminal procedure standard textbook in this area, which starts out with the statement that it is difficult to state clearly the law of Scotland on arrest. And the bill does not provide a comprehensive scheme regulating arrest. It simply sets out circumstances in which that power may be exercised. So I'm not sure this is the place in which to attempt to define arrest comprehensively, or that the Carloway review would actually give us a good basis for doing that. That might be valuable, but I'm not sure it can be done in the process of this bill.
So where would it be done?
Sorry, well, and then back, yes.
No, I mean, all I was going to say is I agree with that, and I think the important point is what's actually happened here is you've clarified what was a previously quite confusing situation where you had both terms being used. You had the detention terminology and the arrest terminology. And I think what you've actually got here is a vast improvement on that, in that you've simplified the structure.
I can't speak for you, but I think the MD and the committee disagree with that. And we were sort of going along the route that we thought the perception. I mean, I know you're thinking in terms of the accuracy of process. Probably we're thinking like politicians, which is perception. And perception is a huge bit for politicians, as well as in the circumstances of somebody who's arrested but not officially accused. And that we will have the situation of Yates where somebody is arrested, released investigatively, and the press will just run, see, they've arrested that man. And I think the concerns would be, I don't know, personally, I don't know why we're changing the term, because I understand the distinction when you've been detained and moved into arrest, different kind of situation for you. I don't understand why we're using the term for both, frankly. I really don't. And I don't know why you're very sound, very solid about supporting this change. Are we, am I misguided? I mean, you can tell me I'm misguided. I'm happy. I get told I'm misguided all the time.
Terminology is maybe as problematic as you think it is. I don't actually see personally that there's really much distinction between using arrest or detention. For one thing, you can't even guarantee that the press will report the terminology accurately anyway. I think the important thing is what you've got here, what's really important here, and the real protection here that you haven't got in some other jurisdictions, is that the period, certainly the detention period, it's arrest now, is actually very short. Now, I see there's maybe more of a problem if you're talking about investigative liberation. That's a lengthy period, but I honestly don't think the term that you use, whether it's arrest or detention, is really important. I mean, if it concerns you that much, you could just swap arrest for detention. It wouldn't actually make any difference really to the bill.
Make any difference to what you do, just a different, it's the label, I think, that's the issue here. But I don't know, does anybody else feel the same, Roddy?
Well, I was just interested in following up Mr. Chalmers' point about where you would kind of seek to clarify that, and what priority should this committee or this Parliament give to that?
I don't think it is a priority, because the general issue of arrest has operated successfully for quite some time, despite the fact that nobody can quite state exactly what the law in this area is. It is an area that could be reviewed by the Scottish Law Commission or an ad hoc working group of some sort to try and bring some clarity. I don't think it's a priority, because it appears to be a workable system at present. If I can just pick up on briefly some of the points that have just been made, the current position is that in England, arrest involves reasonable suspicion that somebody has committed an offence. Detention in Scotland involves reasonable suspicion that somebody has committed an offence. They are effectively then serving the same purpose. I'm not sure that the distinction between arrest and detention is well understood by the general public. It involves somebody being taken into custody, which is largely the same thing. I do take the point about the media coverage that has occurred in England on a number of occasions, but there are two important differences. One is that the lengthy periods of detention which are permissible in England allow a head of steam to build up in a way that would not be possible in Scotland, even after, especially after the Criminal Justice Scotland Bill is passed, if it passes in this form. The second is the rather stricter approach of the Scottish courts to contempt of court, which may affect the way in which Scottish newspapers choose to report cases. I would be surprised if a change in terminology would in itself make any difference to reporting.
Okay.
If I may throw something into the
Yes,
mix of that, I think there's, I don't think the words that one uses to describe it really matter. One has to think about what its function is. And one function is to tell the police what powers they have, so that they are very clear that what they're doing is lawful. The flip side of that is, from the suspect's point of view, what flows from the decision to arrest, detain, whatever it is then. And in right terms, the Strasbourg court is going towards talking about curtailment of freedom of action rather than being deprived of your liberty. And the curtailment of your freedom of action is what is triggering, for instance, the right to legal assistance. So what the committee needs to be aware of is, whatever we call this power, there will be circumstances in which people's freedom of action is sufficiently curtailed that they ought to have legal assistance, even though they're not being taken to the police station. And we saw an example of that in the Supreme Court last year in the G case, in which someone was present during a search under Section 23 of the Misuse of Drugs Act. They weren't given legal assistance because they weren't in the police station, and the Supreme Court said that person was essentially handcuffed and not free to leave. They should have had a lawyer. So that's the difficulty. It's a functional question rather than a question of description, I think.
Elaine. Sorry, Roddy, have you more to...
I finished on that.
Done that one. I'll come back to you later. Elaine.
Yeah, I think the problem is though that, I mean, the words may mean the same thing, but most people, the public, think that when somebody has been arrested, the police have sufficient evidence they may have committed a crime to arrest them, which is rather different than, you know, having a suspicion. You want to know what's going on. The person's been taken in just to find out what's going on, find out what they know about it, rather than actually there is sufficient evidence that person may have committed that offence to trigger the actual arrest part.
I'm not sure that detained wouldn't also carry that implication. I'm not sure one is necessarily any kind of better or worse than the other.
Can I also suggest as well, that your question seems to rest on the premise that first, the public don't know what detention means, and that may be true, but secondly, that might be a good thing, and I'm not sure that is true at all.
They know it's different from arrest. They
so.
may not know exactly the technical things that lawyers know, but they know it's different from being arrested.
But they might not necessarily see it as better or worse. I don't know. I mean,
because if
we're all casting around here and making claims that we just don't know. If somebody wishes to do some sort of public survey into, you know, what is generally understood by the two different terms, we'd kind of have an informed basis to have this discussion. But until we do that, I think we're actually just heading off on a bit of a red herring here, to be honest.
I would be reasonably confident the public know that there's a difference between being detained and being charged with a criminal offence. It may well be the case, but I'm not sure that there is a public understanding that detention and arrest are different things. Now, arrest is normally combined with charge. That is understood as a different stage, but that's not quite the same point.
We could be wrong, but nobody's going to know the answer to this until somebody does some sort of, you know, survey of public understandings. Well, possibly. Yeah.
As somebody says so much for the restraint of the press. See, they've arrested that man, and they haven't put the bit in parentheses, you know, that they've not yet been, what's it, officially accused. I have to keep remembering that. Now, I have a job with that. So we'll I think maybe we're just politicians that are a bit sort of prickly about these things and perceptions. Who knows? Yes, Elaine.
Looking actually at the period of time and the reduction from 24 to 12 hours, and ask for your views about that, because we've heard some witnesses, particularly in the police, have said on occasion you might need a bit more than 12 hours to complete to complete an investigation to be able to be in that sort of position. Should there be some exceptional case, and you know, under what sort of circumstances should that exception be granted?
I think, I mean, personally, I don't have the operational understanding of police matters to be able to say whether there would be exceptional circumstances justifying a 24-hour period. There may be. That's something that the police would be able to advise you on. For me, I think I would be happy with the 12-hour limit. You would have to remember that if we did extend it to 24 hours in exceptional circumstances, you wouldn't necessarily be getting 24 hours in which to question a suspect, because you would probably have to have some sort of break period within that additional time. It wouldn't be compatible with the ECHR to question somebody continuously for 24 hours. In England and Wales, where they do permit extension, they also have a provision in the Code of Practice that says that suspects needs to have, I think it's an 8-hour break from questioning. So in effect, if you did extend the time period in exceptional circumstances, you'd be gaining maybe an additional 4 hours or so at most. It may be that the police are able to give you, you know, convincing evidence of the cases where that might be justified, but I'm not in the position to do so, and until I've seen such evidence, I would be inclined to stick with the 12-hour limit.
If I may say that the Commission has a completely different view. Taking someone into custody engages their rights under Article 8, their right to private life. It interferes with their private life. That has to be justified by the state in terms of Article 8(2). And part of the justification is it must be necessary. And what the Strasbourg Court has said is that that question of what's necessary has to be based on evidence, not anecdote. There is no evidence that a 12-hour period is necessary for the purposes of detaining someone or keeping them in custody. In fact, when the data was collected during the Carloway review, 83% of people were released in less than 6 hours. So going back to Mr Finney's original question about the Commission's comments after CADR and the emergency legislation, we said at that time there was no justification for increasing to 12, certainly not to 24. That remains our position because the evidence hasn't changed. So what we say is the bill should be amended to have a reintroduction of the 6-hour period, because that should be the norm, with a possibility to extend to 12 should there be a particular reason why that is necessary. But the reasons must relate to the provision of Article 6 rights, right to legal assistance, the right to an interpreter, or something of that nature, the requirement for medical treatment, something like that, not about the police want to go and do X while you're sitting in the cells.
Just before you do that, is there, have you finished there, Elaine? Yes, Colin, yes.
Thanks. So just the about the 83% that you said there. I haven't seen, not aware of the figures anyway. But perhaps you could let us know the other 17% that were carried over. Do we have an idea how many of these 17% actually ended up in convictions?
I have absolutely no idea, because that data wasn't collected by ACPOS and by Lord Carloway.
Interesting to know if that was justified as an extension.
Are you on the same point, Alison? Yes.
Well,
Oh, sorry, do you want to come back in?
No.
Alison, yes.
Just following up Elaine's point, really, in terms of the custody hours that are available, could I hear the panel's views on the impact on children and vulnerable adults, and whether or not the 6-hour limit that's being proposed by SHRC should ever be extended in those particular cases?
We've said in our written response that the committee and the Parliament should think very carefully whether it is ever appropriate to hold a child or a vulnerable adult for longer than 6 hours. But one of the recommendations we've made in relation to children in particular, and I know you're hearing from the Children's Commissioner later, no doubt he's better informed than I am, but one of the recommendations we've made is that the bill should say in terms that taking a child into custody is a measure of last resort, because it really ought not to happen unless it's absolutely necessary.
If I could just add briefly, one protection that will still remain is the admission of any statements made in police custody is subject to a test of fairness when the prosecution seeks to lead them in court. And the court would be able to take into account in applying that test if somebody was vulnerable, had been held in circumstances which made it very difficult for them to exercise the right to silence, which made it more likely that they might confess acts that they didn't commit, and so on. Those would be factors that the court could take into account and could actually decide not to admit a statement, regardless of the fact that the legal maximum had been complied with. So the police would have to be very careful about holding somebody who was a child or was vulnerable right up to the wire, as it were.
On the, I'm actually referring to your article in the Modern Law Review at page 849. This is about the children thing. You've got Lord Carloway states there a very strong argument that a child under the age of 16 should not be able to waive the right of access to a lawyer, but does not set out explicitly what these are, other than alluding to the serious nature of cases involving children that are likely to end up in court. So that's the first point I might want to comment on. And secondly, you say that this goes beyond what is done in England and Wales, where an appropriate adult can request legal assistance for a child who's indicated he does not want it, but a child cannot be forced to see the solicitor if he is adamant that he does not wish to do so. They also go beyond what is necessary under ECHR. European Commission on Human Rights has never suggested that children cannot waive procedural rights, although for a waiver to be valid, the assistance of a legal advisor or appropriate adult may be required. Now, I'd like you to comment on that, and also to comment on, we were sort of talking about the difference there is between 16 to 18, and whether we should just move the bar to 18 anyway. So both of those, please. Well, there's more than both, there's several bits. But just to comment on what you've put in there to elaborate on what are we, is this too far? Should we be saying no?
To comment on what's in the article, that it wasn't particularly a statement of opinion by us. The things we've put in the article are correct. In England and Wales, they don't.
Indeed, but I'm asking you whether or not we should be... I'm now asking you,
Yeah, what's our
do we
opinion? Yeah.
require to say
Yeah.
absolutely no child 16 and under is able to waive their right?
I don't think we require to do that. No, there's certainly no legal reason why that's required. I think if I had to offer a personal opinion, I would probably say that we've got it about right in the bill, in that under 16s probably shouldn't be permitted to waive their right to legal assistance, but there are that it may well be disproportionate in terms of the cost involved to impose legal assistance on all 16 and 17-year-olds, even if they are adamant that they don't want it and they are capable of understanding the implications of that decision.
And so you would keep the distinction in the bill?
I think the bill's got it about right, personally.
Okay, fine.
Having said that, I can't claim to be any great expert on child psychology.
Yes, I don't know what to say to that. None of us do. We're trying to do our best with the information in front of us, you see. Yes.
Just to add briefly to that, our statement that this goes beyond what is necessary under the ECHR is not meant in any way as a criticism. It's simply an observation. And certainly, I know that one of the things the committee has been concerned about is the idea of future-proofing the criminal justice system against ECHR developments. Now, none of us can give guarantees as to how the European Convention case law might develop in the future. But this, of course, is an area where the views of the European Court of Human Rights might change, and it would certainly be advantageous for the system to be offering more protection than the bare minimum required by the Convention.
Ms McCall, do you want to comment on the distinctions that exist in the bill? Are you content with those?
The Commission's view is that the bill is right to say that children under 16 should not be allowed to waive legal representation. That's not because, as Professor Chalmers has just said, that's not because Strasbourg says children cannot waive their rights. They can, but Strasbourg looks extremely critically at the circumstances in which that happens, because one of the important things about a waiver of your rights is it has to be with full information about the facts and with full information about the consequences of doing that. And there's a real issue about whether children, in the absence of a lawyer telling them the consequences, can really properly make that decision given their lesser maturity and capacity as compared to adults. And it's not appropriate in the Commission's view to substitute parents as the decision makers for children who are the holders of their own rights. It's not the parent's job to do that, nor is it an appropriate adult's job to do that. And there is a danger that the parent may be just as ill-informed or misinformed about the importance of legal representation as a child may be. That's why we say the bill has got it right in that respect.
Alison.
If we're remaining on children's rights, I wonder what the panel's view on is whether the bill is a missed opportunity to raise the age of criminal responsibility to 12 and on other requirements under the Committee of the Rights of the Child.
The Commission's view, it is a missed opportunity, and the opportunity ought to be taken by this committee to recommend that. It's clear that Scotland has an extremely low age of criminal responsibility. It's clear that the trend internationally is upwards from where we are, and there's a real opportunity in this bill to do something about that, and that opportunity ought to be taken.
I was just checking whether it would fit under the purposes of the bill in any event. And yes, Ms Levitt.
Just going to say, I don't necessarily disagree with that. I think there's an awful lot in this bill already, and there has relatively recently been a long consultation process on the age of criminal responsibility carried out by the Scottish Law Commission, and I'm not sure this is necessarily the best place to try and revisit that.
Where would be the best place then to visit it?
Well, I suppose what I'm actually saying is I'm not sure that it needs revisiting at all, personally.
Okay.
And if it does, that this bill possibly isn't the right place to do it, given that there's an awful lot in it already.
Well, I suppose we want to make sure that we have bills that have an awful lot of the right stuff in it, rather than just an awful lot of things that we're maybe not sure are actually correct.
I don't know whether that's agreeing or disagreeing, but you're a little bit of a mumble to yourself there.
I was having a
That's
mumble,
allowed.
yes.
Mumbles are allowed. Somebody else want to come in, Roddy?
Not on this, a new subject.
You come in on a new subject, yes?
Yeah, if I might turn now to the question of receiving legal advice by telephone. Section 36(3) of the bill describes consultation, right to consultation with solicitor when someone's in police custody, means consultation by such means as may be appropriate in the circumstances, and includes, for example, consultation by means of telephone. What's the panel's view on that particular provision?
Yes, please, just
The Commission's view is that there are circumstances, there will be circumstances in which a telephone consultation is inadequate. And that's because the purpose of legal assistance is twofold. It's first of all to protect the right against self-incrimination, but it's second of all to check on conditions of detention and ensure against ill treatment. And in that second respect, it's very difficult to assess someone's vulnerability in custody over the telephone. One of the other things we would say about Section 36 is that the choice of the method of consultation with a solicitor belongs to the suspect, and it ought to be clear in the bill that it belongs to the suspect. Now, it may be, of course, the police say, well, as I think they do at the moment, first of all, you can have a chat on the phone with a solicitor, but if the solicitor and the suspect decide that the solicitor should come to the police station and be present, that should be the choice of the suspect, not the choice of the police.
Who's going first?
I think it's important to read that provision together with Section 24, which creates a right to have a solicitor present during the interview. But as Mr McCall has said, that's not the only function of a solicitor. I would certainly agree it would be useful for the bill to make it clear that the choice has to be that of the suspect, not of the police.
Can I just add to that as well? I think the point about one of the functions of the solicitor being to be able to check the conditions of detention is an important one. And it's actually in the European Directive on the right of access to a lawyer in criminal proceedings, it's actually set out in there that that is one of the functions of a solicitor in this situation. And therefore, I think we have to make sure that we're complying with that. And I think that means if somebody wants their solicitor to visit them outside of the interview situation, I think we probably have to allow that.
Okay, so
now, yes? You finished?
yeah, I've basically finished. I thought
Well,
Colin
but
was
no,
gonna
you
do-
can't
Yeah.
select them because I've got John Pentland waiting,
Okay,
you see.
fair enough.
But I just want to know if you're going to ask about vulnerable witnesses. That's fine. That's your, yes? Were you going to ask about that?
There's actually just some clarification of what has been just said.
Well,
In terms of those people who are perhaps up in the darkest highlands and engage say a Glasgow solicitor, and how that would affect.
I don't know if the darkest highlands would like to be called the darkest highlands. It might be the glorious, sunny autumnal highlands, but there you go. Yes, you can ask that, and then it's John.
Well, that was basically it, is the effect of the way things proceed. If you have someone who's up in one of the Highlands Islands areas, not terribly accessible, and you're asking you get the telephone call, and it's decided that the solicitor has to travel, particularly if they come from Glasgow or Edinburgh, Dundee, somewhere like that. There is a time element. And I'd like your comments as to how you would see that progressing in a practical sense.
I'm not the best person to answer that because I don't have the practical experience to be able to do so.
I can answer that. From an Article 6 point of view, from a human rights point of view, the state ought to respect an individual's choice of legal representative insofar as that is possible to be done. So if an individual is in custody in the islands and says, I want to speak to Mr. Smith in Glasgow, that should be facilitated if it can be facilitated. But if an appearance in person by the solicitor is required, that may be a situation in which it's legitimate to say, well, we can't respect your choice of solicitor in this instance because it's going to take him 9 hours to get here, but you can have Mr. Y from just down the road who can come and visit you and perform the function of being your legal assistance in this situation. And that may be a legitimate occasion on which to depart from someone's choice of representative. But the point of it is the state has to have measures in place so that solicitors can be brought to the police station to perform that very important function.
bit of common sense in there about, yes.
That's been
John
sadly missing.
Finney's, John Finney's face was a picture when you referred to the Darkest Highlands. I just thought I'd say that to you.
Interesting geographic term, I was thinking.
Oh, absolutely, absolutely. But no violence, John, no violence. John Pentland, please.
Thank you. I wonder if the panel would care to expand on their views with regards to vulnerable adult suspects. HHRC reckons that the bill might be too narrow as it focuses only on those people with mental disorder, and Professor Lerverick and Chalmers have stated that it's notoriously difficult to identify vulnerable adult suspects. I wonder if you would care to expand on your views.
There's a real challenge in identifying vulnerable people, undoubtedly, and that, as we've said in our written response, is really about properly training the police. It is good to have an understanding that mental disorder, as it's defined in the Mental Health Care and Treatment Act, gives rise to vulnerability. So that's encouraging. But what will be missed in that definition is people who don't suffer from mental disorder but who appear, for whatever reason, not to understand what is going on. That may be because they've taken some intoxicant. It may be because they are medically unwell rather than mentally disordered. It may be a language communication issue. There are all kinds of reasons why people's vulnerability in custody can be increased. And the bill at the moment doesn't allow the flexibility for the police in relation to those people who are not evidently mentally disordered. And we would encourage some amendment in that respect.
Can I just add to that and say I agree entirely, and not that we have to necessarily follow slavishly what happens in England and Wales, but the equivalent terminology used in the legislation in England and Wales is it refers to mentally vulnerable suspects without any necessity that there is some sort of mental disorder as such present.
Can I just add, perhaps, they're just looking at the provision of support for vulnerable people. The provision refers to somebody who, owing to mental disorder, is unable to understand sufficiently what is happening or to communicate effectively with the police. Now, in some respects, it might seem slightly odd that somebody who is unable to understand sufficiently what's happening or to communicate effectively for another reason does not fall within the scope of this section. And if somebody met that criterion, the support would effectively have to be provided, because otherwise, if they made incriminating statements, the courts would in any event hold them inadmissible because they would not meet the fairness test.
Yeah. I think that's a fair point to make about that section. John, do you want to?
Sheila, you said that perhaps one of the measures that need to be put in place is obviously for properly training of the police. Is there any other measures that you think may be necessary?
I think some concerns were raised in written evidence to the committee about the funding for appropriate adults, and obviously the state has an obligation to put a proper system in place. So there has to be a conversation and a decision about how appropriate adults are going to be paid for. And the second issue is to ensure that appropriate adults are properly trained. And I know there's some provision for making regulations about that, but training would be very critical, and also ensuring that appropriate adults are used in the right way, not the wrong way. So they can't be substitute decision makers. They are just there to facilitate communication and use their expertise for that purpose, which is why we welcome the view that vulnerable persons shouldn't be able to waive their right to legal assistance, so that there is someone there who's capable of properly advising on decisions to be taken by the vulnerable suspect.
And a protection in court, I think, would also be inadmissible if a solicitor was able to show that they've been oppressive or something to somebody who was vulnerable in that evidence was taken. Roddy, are you still on vulnerable people?
No,
you're not. Right, so it's not you next, it's Elaine, who's not vulnerable people.
Right. No, I'm not on vulnerable people today. Lord Carloway expressed some concern about the period after somebody's been officially accused, and then they can either be released or liberated and undertaken, or they may be detained prior to going to court. And he expressed some concern about the period of time which could elapse between being officially accused and actually getting into court. That's not addressed in the bill at all. Do you have a concern about that? I mean, I presume that some of the reason that's not addressed is because of resource issues, but I just wondered whether you think that ought to have been addressed in the bill.
Ms Leverett, you're nodding, yes.
I agree entirely with his sentiments, and I think the period of time potentially is unacceptably long. Now, whether this ought to have been addressed in the bill, I'm not sure. It is addressed in the equivalent legislation in England and Wales. I think it probably has to happen that we do make some sort of provision for weekend, perhaps holiday court sittings, and if that, obviously that's going to have a resource implication. But whether it needs to be addressed specifically in the bill, I don't know. Possibly if practice doesn't change without legislative intervention, then possibly it might have to.
We in Scotland have been at the outer reaches of breaching Article 5 for some time, Article 5 being your right to liberty, which is the reason that Lord Carloway recommended in his review a period of 36 hours be introduced, because at the moment he identified situations where a suspect may be there for 4 days or so before appearing in court, and that is pushing the boundaries of a human rights breach. You're right to observe that the bill does nothing to address that concern for Lord Carloway. The Commission's position is that the rule has been the same for many, many years, and the situation has not improved and working practices have not changed. So a legislative solution, in our view, is necessary, and Lord Carloway's original recommendation would be an appropriate way to solve the problem.
Do you have any concerns about the possibility that somebody could be questioned after charge? Because that obviously is a new development in this bill.
It's not something which I would personally have any concerns about, given the safeguards that are in place, and in particular the requirement of an application to the court before that happens.
I would agree with that. I think with those, if there weren't those safeguards in place, I would possibly be concerned about the issue of kind of repeated harassment of people who are being held in custody. With the safeguards in place and the fact that the suspect, or the person accused at that point is going to be notified of an application being made to the court, so it's not going to come as a terrible surprise to them, and they're able to make representations as to why this might be inappropriate. I don't have any particular concerns about it.
The Commission does have concerns about it. In European human rights case law, there's nothing that prohibits questioning after someone is officially accused. But one has to think about what the purpose of it is. And if its sole purpose is to overcome someone's right to silence, in other words, to get them to incriminate themselves, that may breach Article 6. That may breach their right against self-incrimination. And having thought about it before coming here today, it's very hard to think of situations where the questioning would be designed other than to do that, other than to try and get them to say something against interest when confronted with, for example, DNA evidence or CCTV footage or something of that nature. So I think there's a real danger there in terms of the purpose of the questioning, whether it might fall foul of Article 6. But as a matter of principle, there's not a difficulty with it. I'm just not sure the protections of judicial oversight are sufficiently robust.
If the sheriff consents to questioning post-charge and the accused refuses to say anything, I don't know, would this be held against them in proceedings, the right to silence? If they say, well, you know, I'm questioning, but I'm not going to say anything.
We think that it should be made express in the bill that if the person chooses not to say anything, no adverse inference can be drawn, because Strasbourg is moving towards saying drawing an adverse inference from silence is a breach of Article 6. They're not there yet, but in our view they are likely to start to go there, and we see the withdrawal from that position in England. They're backing off that position. It'd be very foolish for this Parliament to introduce a bill that walked into that potential situation.
So at the moment, adverse inference can be drawn from silence.
It's not clear.
It's not clear.
It's not clear because this is not a method of questioning that's ever been allowed before.
Okay.
So our recommendation would be that the bill should be amended to include no adverse inference.
No comment. Do you want to comment? I mean, you don't have to if you don't. But it just occurred to me that what can be drawn from that? You know?
I would be surprised if the courts felt able, on the basis of the bill as it stands, to draw inferences from a failure to answer questions in this situation. But there would be no harm in making that explicit.
And was that what you would wish?
I would certainly agree there should not be any possibility of drawing adversaries
Okay.
in this situation.
I suspect it probably wouldn't happen anyway. I suppose there would be no harm in actually putting in a specific provision to that effect.
But but when we're at stage one, of course, we're looking at things to raise and debate and then to
Yeah.
have responses to. So
Yeah.
it's important to tease these out. Roderick, have you?
Yeah, it's a different matter, but I'll change my question what I originally intended. Lord Carloway made reference to the possibility of Saturday courts to reduce long periods of delay in getting court appearances. Does the panel have a view on whether the bill's adequate in ensuring that suspects are not held in custody for too long before court appearances, or could it do better?
I would certainly endorse what Mr Call has already said on that point. And this is something that could be dealt with without legislative intervention, but we are, in practice, at risk of eventually running afoul of Article 5 of the European Convention, and that may require Saturday courts.
I suspect we do need Saturday courts. Whether we need legislation to bring that about, I'm not sure.
Are there issues about court closures then if you're trying to have Saturday courts if the courts aren't there?
Well, we have plenty of space in courts on Saturdays, so I suspect that's not the issue, but it's the people to put in them.
Yeah, I guess I wouldn't be terribly happy personally if I was the one who had to work in the Saturday courts, but I think it's something we do need to do, unfortunately, with all the implications that has for the people who then have to work on Saturdays and resource implications and so on. I think it is sadly necessary.
You might have to open up a local court again and take the key in it and let them in for the Saturday. Get the Janny to open it, especially. Yes, Sandra.
Chair, I don't know if this particular, I certainly didn't hear any question on this particular one in section 4 of the bill in regards to, you know, an arrested person being taken as quickly as reasonably practical to a police station. I just wonder if you have any concerns or any comments in regards how that would affect the police or the suspect as well. Well, would it have an adverse effect on the suspect or an adverse effect on the police? Or could it be a good thing? It's reasonably practical to a police station. Some of the arguments about that is the fact that the police may act too quickly in taking people to the police station, as that is part of the bill in section 4.
There might be an argument that the police in some circumstances would arrest someone too quickly, but I'm not sure that's something that can be addressed here. This is not a section about which any concerns have occurred to me at all.
I think it's the, I think it's the, once the decision's been made to arrest someone, that's the critical decision in terms of interfering with the person's private life and liberty and so on. So if the consequence of arrest is that certain rights need to be facilitated, like legal assistance and so on, the quicker that is done, the better, because then the less time someone may ultimately spend in custody. But where I think your question's interesting is in the grey area before the decision is taken to arrest somebody. And in our view, that's properly addressed by the police facilitating legal assistance wherever they are and not having to go to the police station for that purpose. So it's not about taking people too quickly to the police station, it's about unnecessarily taking them to the police station.
On the other hand, you know you're taken to the police station, you're in trouble. And if you, to take you back to your point, if you're questioned in the house, you might not be aware of it, but if they've taken you reasonably practical police station, the whole agenda has changed.
Although if you're given a proper and full caution when the police arrive at your door, we have grounds to suspect you have committed the offence of blah, you needn't say anything,
Okay.
you're entitled to a lawyer and so on. It's brought home to you through the caution that
Right.
I need to be aware, I'm in trouble and I have certain
Yeah.
rights.
Right, but can I don't think we've any, have you anything else you wish to perhaps say to us, other than what a lovely panel we are here, but today, you compliment us for that. But anything, Jenny, you wish we'd asked you that we haven't asked?
Thing I would say, and it follows on from Sandra White's question, is we would recommend that the reasons why you're taking someone to the police station ought to be defined in the statute. For example, we're taking you there to question you. We're taking you there to recover evidence that we couldn't recover otherwise. We're taking you there because we think you might destroy evidence that we need to get. So specific reasons for arresting someone and taking them to the station would provide clarity for both the police officers and those being arrested.
John?
This may have been covered, I don't think so, Kinera, and forgive me if it has. About investigative liberation, sections 1417, and the Commission, Ms McCall, talks about the implications for a suspect's work and family commitments connected with that, and the implications that may have in respect of Article 8. Could you expand on that, please?
What the bill envisages is, as I understand it anyway, being released on this investigative liberation with some conditions. For example, it may be you have to come back to the police station at a particular time. That may not be a convenient time in terms of your caring commitments or your important work commitments, or indeed your solicitor's commitments. So there may be some issues there about it. There may also be conditions like a curfew, and that's a serious interference with someone's private life and may in fact interfere with the right to liberty. And there is not enough limitation in the legislation built around that. In other words, in terms of the reasons why you would do it, what the limits of it would be, when it would be appropriate and when it wouldn't. So we think that section, as we've said in our written response, could be improved by a bit more scrutiny of these sorts of issues.
Is your concern that the police would look at the full range of options, curfew, timings and all the rest, and de-escalate them due to the level of compliance by the accused, shall we say, rather than evidence escalating the conditions?
Exactly, and from a point of view of interfering with someone's private life, it's for the state to justify how far they're going, and they should only go the minimum distance necessary to secure the aim they're pursuing, such as the proper investigation and detection of crime.
So if we stick with the curfew, then how would you see that being recorded? Would you see it being forming part of the ultimate report that goes to the Fiscal Service, or how would you see it being recorded that the reason why we've suggested liberation but with a curfew is?
Well, one of the things we suggest that could address that, and it's similar to the bail provisions at the moment, is you could have standard conditions. For example, you'll be of good behaviour, you won't interfere with witnesses, these sort of things. The application of additional or extra conditions like a curfew should only be to secure compliance with those standard conditions. In other words, is a curfew necessary in order to make sure you are of good behaviour or you don't interfere with this particular witness or behave in this particular way? And all of that should be recorded in the police report, so there's a proper record of why things are done, because there's an opportunity for the fiscal to scrutinise that, and there's an opportunity for the sheriff to scrutinise that, so it needs to be properly recorded at that stage.
And the implications for the system if these are disproportionately applied to an accused person?
Well, the implication for the system is that the accused may have some claim for breach of his rights. You may unnecessarily burden sheriffs with reviewing investigative liberation conditions. You may clog up the fiscal's time reviewing and remedying inappropriate conditions.
Okay, thank you very much. Thank you.
The end, because John's down again now. I thought we'd finished. No, it's a postscript, please.
Try to catch your eye, Chair, but you actually turned your head.
Oh, dear me. I'll make a point of it from now on, John.
Thank you very much, Convener. Prevention, it's often said that prevention is better than cure, and in section 1 of the bill, police witnesses have argued that it should be amended as to clearly empower the police to arrest a person in order to prevent crime. Could I have your comments on that, please?
I suppose there are two comments I could make on that. One is that I know that witnesses last week referred particularly to the Police and Fire Reform Scotland legislation as a suggestion that because the police have a statutory duty to prevent crime, they might therefore need the power to arrest to prevent crime. I find it slightly surprising that this is not presumably a new duty of the police. I think that for some time the police have had a duty to act to prevent crime. I'm not sure the legislation creates the need for a new power. I can see an argument for a power to arrest to prevent crime, but I would want a little more detail on what that, how the police would envisage exercising that power, because I'm not entirely clear what would be done with somebody who is arrested solely for the purpose of preventing a crime. unless they were suspected of attempting to commit a crime or conspiring to commit a crime, in which case they can be arrested because they've already committed a criminal offence and brought before a court. If somebody has not committed a crime of any sort, I'm not sure what would be done with them once they're arrested. And if there is going to be a move to create a power of this sort, I would like some clarity on that from the police who have suggested it.
I would add that, again, if you look to the equivalent legislation in England and Wales, that is covered. There is a power there to arrest if there's reasonable grounds to suspect that someone's about to commit an offence. But like Professor Chalmers, I'd like to know a little bit more about how that actually works, because if somebody actually hasn't committed an offence and you've arrested them, what do you do with them next?
There have been some European cases following on from the exercise of that power in England, and they have not gone in favour of the police. We would be extremely concerned about the idea you can arrest someone when they have done nothing contrary to the criminal law. At the moment, Section 1, subsection 3 sets out reasons why a constable can arrest someone for a non-imprisonable offence. That's what it's talking about there. And one of those is continue committing the offence. That would seem to me to cover the situation where someone has begun and the situation is going to escalate and the police want to intervene. So we would suggest that that list that is there is probably adequate to assist the police in that situation.
I think it's worth noting, and this may echo some of the evidence you received last week, that the Scottish law of attempt and conspiracy is rather broad. So a conspiracy is committed at the time that any two people agree to commit a criminal offence. An attempt is committed not at the last minute before a crime takes place, but at the point when the accused moves from planning a crime to perpetrating the crime. Both of those devices allow the police to intervene at a very early stage. And as Mr Wall says, it's quite disturbing the idea that somebody could be arrested without having done anything contrary to the criminal law, and it's not clear why that would be necessary.
I'm looking in your direction now very carefully. I'll make a point of it. I'm not going to say there's no further questions because they're bound to put their hands up. So I'll just say thank you very much, and we're now going to suspend for 5 minutes. Thank you. Back we come. I welcome to our meeting our second panel, Tam Bailey, Scotland's Commissioner for Children and Young People, Mark Ballard, Head of Policy, Bernardo Scotland. Welcome, Mark. We will be gentle with you. No, we won't. Rachel Stewart, Policy and Campaigns Manager, Scottish Association for Mental Health, and Morag Driscoll, Director, Scottish Child Law Centre. Can I thank you all very much for your written submissions. I know you sat through much of the previous evidence session, which is, thank you very much. It's very helpful to us as well. And can I have questions from members, please? I'm looking to my left in case there's a question. Come, John Petland.
Thank you very much, Convener. Yeah, the last session you probably heard me asking questions about the vulnerable adult suspects, and probably without me going through the whole gambit again, probably could have maybe your views on that.
Now, can I just say as before, just let me know if you want to answer, and your microphone will come on. So, Ms Driscoll, do you want to come in there?
I didn't hear all of the evidence from before, but
it's Ms Stewart that you're in.
We came together.
Arrived at the same time, so I also missed the.
I think it was a question about the narrowness of the definition in the section 50. What is it, John? Section.
I think probably Mark's going to pull us, help us here by answering the question.
I think we would, as Bernardo Scotland, very much agree with the position taken by the Commissioner that vulnerability not only includes a mental disorder, but physical disorders, language difficulties, intoxication, and crucially for Bernardo's, as I think is recognised in section 42 of this bill, by age and stage of development. And I think there's a confusion caused by the fact that vulnerability in the rest of the bill seems to rest on having a mental disorder. I noted in particular what's said in the policy memorandum, where there's a discussion of, if, and I'm quoting the policy memorandum, if the 16 or 17-year-old is considered vulnerable, i.e. they have a mental disorder and cannot communicate effectively or understand what is happening to them, then they will not be able to waive their right to legal advice. I think we've got to be clear that vulnerability for a 16 and 17-year-old may well be due to the age and stage of their development, not due to mental disorder. So I think there's a problem that there are multiple definitions of vulnerability, but they're not properly drawn out, and particularly that the reliance on mental disorder as the determinant of vulnerability is unhelpful, because there are many more reasons why both adults and children and young people can be vulnerable and then require support specifically to deal with that vulnerability.
Tam Bailey, yes.
Yeah, it's a thankless task trying to define vulnerability. And the policy memorandum has made a stab at it. We could make suggestions about improving it. At the end of the day, though, it's going to come to judgment. And judgment will have to be exercised on the basis of experience, on the basis of training, on the basis of guidance. Now, you can't just have blanket coverage. There are certain times we want to identify those who are vulnerable as opposed to those who are not. And I'm sure when we come on to talk about the waiver, etc., and our views on that, because that's really where the vulnerability clause comes in. But it's really quite difficult to define vulnerability. I've had previous experience of running hostels for children and young people where we would take the most vulnerable, and we ended up not trying to define it too tightly, because in fact it was down to individual judgment at the end of the day. But that needs to be backed by one of the key things in the bill, which I think is the training and guidance that's offered as a result of the implementation of the bill.
If I take the panellists back to section 33(1)(b), I think that's what John was looking at, the expression, 1C, owing to mental disorder. That's, I think, the bogey phrase there. Yet, I was going to go back to Ms Stewart about it, because I think you've explained the complexities of defining vulnerability.
I mean, from SAMH's point of view, the mental disorder definition, which comes from the Mental Health Care and Treatment Act, is quite a wide range within mental health problems, learning disabilities, personality disorders, autistic spectrum disorders. And each of these different conditions would require a different response, different training, different support. So from our point of view, it is quite, while, as you say, it's narrow and it just takes one condition or one disorder, it doesn't actually set out how people would be needed to be treated. Sorry, I'm not being very clear. I think that you could argue that anyone in custody is vulnerable. It's a stressful, anxious environment for people to be in, and police need support and training to be able to support those people who are in that situation.
So there might be some right toughies, though, in custody, or not that
Absolutely.
vulnerable. I was thinking that I think we might have a dispute about that. John, do you want to get back to that issue?
Just
Yeah.
very, Tam Bailey, you also mentioned that training is obviously very essential for us to take place. Your organisation, Rachel, goes that bit step further and talks about we need to set up a standalone service called Appropriate Adults for Service. Would you like to expand on that? And I think you also mentioned that there has to be a closer relationship between NHS and Police Scotland. Has to be strengthened. Is there a weakness there just now?
To take the appropriate adult issue first, we welcome the inclusion of it in the statute, but we note that there is no plans within the policy memorandum to set up any backup for the services and the schemes that run as is at the moment. They currently run across Scotland in different guises. Some of them are funded, some of them rely on social worker extraction. We think that to improve the patchy nature of the service at present, it would be better to fund it, to resource it, to ensure that the appropriate adults receive good training and support, that they're retained, that they have assistance to deal with some of the issues that they would hear and improve their own mental health. We think that currently some people are getting a good appropriate adult service because there is that kind of backup. If there are others who are just waiting for several hours and then getting a social worker who doesn't potentially have the training in a certain area, then they may not be able to be facilitated in the same way and their rights could be affected. The second point was about NHS and police links.
You see in your report that it has to be strengthened. Have you identified a weakness that exists there just now?
I think that there is a role. Obviously, a lot of people coming into custody would be in crisis. You have some pilot schemes in Scotland where you've got NHS and the police working together on alcohol issues, and it could be a situation where if someone was in a custody suite with severe anxiety or depression, who might not need an appropriate adult to help them communicate as such, but they may need a nurse present to say, actually, they need to see a doctor, when was the last time they took some medication, issues like this, then that would be the level of support that we would like to see. There is a bit of a precedent in that the NHS is now providing NHS treatment within prisons nowadays, so the links between the justice and the health services are closer, and we think that should be carried on to its logical conclusion.
The Aberdeen City Council Appropriate Adult Service highlighted in its written evidence the issues around the fact that Section 33 only provides statutory support to those over 18 who are deemed to have a mental disorder, and there's a gap in terms of 16 and 17-year-olds in the legislation. The policy memorandum states that the Scottish Government expects that the police will still be able to request the support of an appropriate adult for vulnerable suspects and accused persons aged 16 and 17-year-olds, and also for victims and witnesses aged 16 and over through the current non-statutory route. Well, we have concerns that if it's not a statutory requirement to provide this service, local authorities under severe financial pressure may not support the provision of this service. So it's not clear how this support will be guaranteed unless it's made statutory in the legislation.
I'm a bit confused. I'm looking at appropriate person, which I think is what we're talking about, rather than appropriate adult. The term in the bill is appropriate person, isn't it?
Yes.
And at section 31(5), it defines appropriate person. And it doesn't seem to me that has to be somebody provided by the state or by a voluntary sector or anybody else like that. It just says It says, if a council believes the person, let's take subsection B, if a council believes the person in custody is 16, an adult who is named by the person in custody and to whom a council is willing to send intimation. So we're putting it into more of a straitjacket of professionally trained people, rather than it might be your granny could be the appropriate person. Am I right? Am I misunderstanding this? I thought... I'm for grannies, yes. Yeah. Tambili, yes.
Yeah, just a point. I mean, you've been mentioned there about appropriate person for 16, 17-year-olds, but elsewhere in the policy memorandum it talks about responsible person, and in fact, COSLA, I think, has already made representation that if the assumption is that that responsible person for a 16, 17-year-old is a social worker, then in fact that is going to put, you know, in cases where it's not a parent or a carer, that's going to put additional pressure on local authorities. So there are resource implications there, and I think representations have already been made to the committee on that.
But that's not in the bill, that's just in the policy memorandum.
Yes, yeah,
I appreciate that, but at the end of the day, it'll be the bill as finalised at stage 3, which becomes the letter of the law.
Yeah.
Are you saying we need to clarify this area?
I think
just leave it the way it is?
I think you need to be assured of the resources being there to be able to actually fulfil whatever statutes are in the bill. Just to make an additional point about vulnerability, you might well want to look at the Additional Support for Learning Act, which did make a reasonable attempt to define vulnerability in terms of children that would be appropriate for additional support for learning. It's a very complex issue, and especially if there's discretion built into the bill on the basis of vulnerability, then you don't want to have to reinvent how it's been approached previously, and that might be useful for you.
Noted, John. You noted. I don't want to offend you, see, so I'm coming back to you so often now. You're actually being preferred. Sandra, followed by, is it? I must look to my right now in case there's somebody to my right. Yes, Alice and then Elaine. Thank you.
Thank you very much, Chair, and good morning. I think some of the answers to the previous question I was going to ask, but I'll still push on anyway regarding the proposed ability of 16 and 17-year-olds to waive the right to access to legal representation. We heard from the first panel, some were quite happy with that, as long as they had proper representation there, and you said yourself, Mr Bailey, sorry, that it would be a legal representative. So I just wanted your thoughts on the fact about the proposed ability of 16 and 17-year-olds and whether it would be parent, guardian, social worker or legal representative would be the best person there. But whoever wants to answer, sorry.
First thing to recognise is that a child is under the age of 18, and for that I give a very big welcome, because that is consistent with the United Nations Convention on the Rights of the Child. So that's the first thing. And that's consistent with some other discussions that have taken place in this room with regard to vulnerable witnesses and victim bill. The second thing, though, is about recognition of whether the view or voice of a child should be taken into consideration. And there's a judgment again to be made, and Lord Carloway has made the judgment that there should be some cognizance given to the views of 16, 17-year-olds, in that they would be able to waive their right to legal representation. They would still have a responsible person, but they could waive the right to legal representation. If they don't have a responsible person, my understanding is that they would have to have legal representation. I think that when I say there's a judgment, there may well be young people who are vulnerable who you would wish to have legal representation. So it's a judgment call. In my estimation, I think it's just about the right balance. But I do recognise that there may be pressures where people would say, have it blanket. But have it blanket would then create other resource implications. So, and I'm mindful of the previous representations that were made to the committee about being very careful if children, as defined 16, 17, waive their right to legal representation. So it's a judgment.
Yes, Mr. Driscoll.
We have some real concerns about this. Age of majority, as Tam rightly points out, is 18. If a young person is committing or believed to commit an offence, they will normally be dealt with through the children's hearing. We get calls about this to our advice line, 3,800 calls last year, and a substantial number dealt with criminal matters. And we are finding that young people are waiving their right to a solicitor when they should have had one, either because they didn't understand one autistic youngster who was offered a lawyer, and when his father, who wasn't allowed to be with him at that stage, said, "Why?" he said, "What's a lawyer?" We also have young people whose parents will say, "Oh, you don't need a lawyer because you're innocent." Now, the young man who didn't know what a lawyer was had a social worker with him. So there are so many stresses and assumptions that can be made by a young person. I don't need a lawyer, I'm frightened. I really worry about being able to waive, and having somebody with you is no guarantee that the right decision will be made. I would rather that we erred on the side of providing legal representation for people who are not considered unvulnerable enough to be full adults than say, well, we will recognize now having a parent is not necessarily appropriate because parents no longer have the right to direct once the child has left 16. They have the right to guide. If the young person wants their parent, that's great, sign of a healthy relationship, but it may not be a healthy relationship. It may be one fraught with difficulties. The parent may themselves be involved in the crime. So the young person having the choice, or by a default, bringing in a professional where necessary. Yeah.
Them as well.
The parent could be the victim.
Other way around.
Another sibling could be a victim. There could be all sorts of conflicts set up. But I worry about saying, well, they're 16 or 17, we will recognize their autonomy, which is great, but there must be protections built in, particularly if this is a high-functioning child with an autistic spectrum disorder that nobody realizes. Somebody who's in care may be more appropriate to have their foster parent with them.
You know, come back to the judgment of what is vulnerable then, though, that kicks in.
Yes, but
you can't,
we should...
And I think there is an issue, of course, of the evidence. If somebody is vulnerable and they don't get protection, that evidence could be disallowed.
So perhaps we should have a presumption that under 18 you are vulnerable unless we are sure you are not, rather than you're not vulnerable until we are sure you are.
I'd have difficulty with that, I think, but that's just mumbling away to myself here about an 18-year-old with 2 kids is presumed to be vulnerable.
And 17, under
17-year-old with 2 kids is presumed to be vulnerable. Tam Bailey.
Yeah. I mean, I'm not going to go to the wire on this one. I think the bill has just about got it right. I recognise some of the reservations that Morag's raising. If the committee feels strongly that that should be no discretion and that should be there as a matter of course, then again you need to satisfy yourself that that's manageable and that it will in fact achieve the result at the end, which is proper safeguards for children and young people. At some point, we have to actually look at definitions of vulnerability in any case.
I wasn't suggesting that there should be no discretion at 16 and 17. What I'm saying is we should require to be satisfied that this young person actually understands what they are waiving.
Mark Ballard, yes. I never know how to call people, you know. I know you all, but we not to be chatty in here. You're not allowed first names. So Mark Ballard, yes.
Bernardo Scotland entirely shares the concerns raised by Morag Driscoll, and again I think there's an issue about what's said in section 42 that when constables are deciding whether to hold a child in custody or interview a child about an offence, then the well-being of the child should be a primary concern, and that's for everybody under 18. And then the way that it works in terms of the relevant sections in 30 and 31, where in section 32, intimation must be sent if the child is under 16, but it may be sent if a child is over 16. In section 33, intimation is to be sent to the parent if the child is under 16, but to any person reasonably named by over 16s. And in 31.5, where appropriate person for under 16s means any person the constable considers appropriate, but for 16 and 17-year-olds, any adult reasonably named by the young person. And it seems to us that there's an inconsistency between a blanket position in 42 that under 18 you are a child and your well-being should be the primary concern, and treating 16 and 17-year-olds in 30 and 31 as if they are adults and in the same category as adults. And that seems to be a disconnect between two different sections of the bill. And Tam Bailey is quite right to say that there's a judgment that needs to be made, but from our point of view, there does seem to be a disconnect about whether we consider those under 18 to be children, as in section 42, or consider them to be adults, as is effectively done in terms of intimations in 32.
That doesn't get recorded. Shrugs and faces and, you know, you have to say something.
Okay. I don't have a problem with increased protection up to the age of 18 at the same time as increased recognition of the capacity of children as they reach 18 about their voice, their views, their opinions. I don't think there's a contradiction in there. However, it does come down to
point to make. I think one that the committee will probably reflect on in its stage 1 report, the conflicting views about the differences between under 16, 16, 17. You were going to, Elaine was going to draw attention to something
yes,
here.
Just section 25. It was the issue of consent to interview without a solicitor. 25 to B 1 and 2 define what would consider to be unable to understand what's going, basically is unable sufficiently to understand what is happening. So surely the young person who didn't know what a solicitor was or thought they didn't need one because they were innocent, would they not be caught by that
You're
clause?
relying on the police doing the interview to spot it. And somebody who is apparently high functioning, you won't necessarily spot it. You're asking for a lot of expertise in spotting these things from frontline police officers, which is worrying, particularly so many of these kids appear confident and appear to know what is going on, but actually do not and are very reluctant to say, I don't get it, and may just retire into the no comment, or as some young people have said, it was easier to say I had done it.
Okay, so you've made that point. So Alison, followed by Elaine, followed by John Finney.
Thank you. I want to turn to the length of time suspects can be held in custody, and the bill reduces the 24-hour maximum detention at the moment, but we heard from the previous panel that the SHRC would like to see that reduced down to 6 hours, and particularly heard them questioning whether it was ever right for vulnerable or young people to be held for longer than 6 hours in custody, and I'd be interested in the panel's view on that issue.
We feel very strongly at the Child Law Centre that consideration should be given to how long a child should be held, and also whether a child should ever be held in a police station. We have protections in the Children's Hearing Act about children not being held in police stations unless absolutely necessary and for the minimum time. Vulnerable witnesses can be interviewed in much more relaxed surroundings, such as in the amethyst rooms. Maybe we can look at things along those lines. If a child has to be held because of behaviour, can we look at alternatives? We do have units, we do have other places that children can be held. Also, we need to look at the length of time. Is it appropriate to have the same amount of time a child is held as an adult? So we'll have some real concerns about then. We do have the idea that we could question children at home. That sounds wonderful, but we're getting too many calls where children have not had solicitors because the family been told by the police, well, we could talk to you at home, you can have a lawyer, but you'll have to go to the police station for that. So children are being done, because a parent is torn. What do I do? Take my child down to something that I've seen on television? Or do I have them at home, but then they don't have a solicitor? So there are some real tensions about where we interview children and where we hold children. Sometimes it will be necessary with a child that is really going off the scale or has been accused of something that is very, very dangerous. But we still have to look at the appropriateness, and we have it elsewhere in the legislation.
So can I clarify, well, two things. Can I ask you to explain what amethyst room is? But also, would you want to see, I think you mentioned amethyst room, where they could be interviewed?
Well, normally when child witnesses or people who are alleged to be victims of a sexual offence who are interviewed, it's the specialist police squad, the Amethyst squad. And the rooms tend to be very comfortable, a sitting room, you know, padded chairs, a camera that can record it, and a much more comfortable environment rather than being interviewed in a normal police interview room with the hard furniture that's stuck down, and it usually doesn't smell very nice either.
I haven't always got that image of somebody under 17 who's taken in by the police as being this sensitive flower, you know, and without prejudging them, some of them can be tough.
Yes, they can, but I was talking about from 13 upward.
To
maybe 16 or 17. You know, they're not all tough, because if they were all
I never
that
said
tough,
that,
we wouldn't
but
be
they're not
sending them
all
through the children's hearing system.
They're not all shrinking violets either, you know, so I'm just kind of balancing it here with
but that's the point. There
what
must,
the public
that's
see.
what I was saying. There must be a balance between the vulnerable accused, who might get better information out of an interview which was less intimidating environment, and the tough nut who's been there lots of times before and is quite proud of it because they come from a family that regard this as a rite of passage.
We understand.
But there is a balance. But I always question whether we should automatically hold children in a police station, and it's in the Children's Hearing Act already.
Cam Bailey, yes.
Yeah. I started by saying I warmly welcomed the bill's definition of a child as under the age of 18. That's because it's consonant with UNCRC, and in fact, to be in line with UNCRC, it's quite clear that a child should be held or detained as a last resort and for the minimum possible period. And I think that should be one of the approaches that's adopted within the bill. And if a child is detained longer than 6-hour period, then there should be very stringent safeguards as to why that would be the case. And I mean, we already attend to this very diligently through the children's hearing system in terms of children being held in secure accommodation. There's very strict rules about that. And I think we should bring the same discipline, or there's the opportunity to bring a similar discipline through this particular legislation on the basis that they are children under the age of 18.
Do you want to? Oh, sorry, Mark Ballard, yes.
Yeah, I would agree entirely with that. And again, I would draw the committee's attention to section 42 of the bill. And I think there's a problem, again, that the kind of stringent safeguards which Tam Bailey talked about should be built into the early parts of the bill which deal with things like arrest. But there's no clear link drawn at the moment between the different treatment of children, which is outlined in section 42, and those early parts of the bill that, as Alison McInnes point out, deal with things like the length of the 6-hour and 12-hour stay in a police station. And that needs to be drawn out more fully to enable the police to understand how to take into account their responsibilities under section 42 of the bill.
Yes, Stuart.
From the point of view of vulnerable suspects who may have a mental disorder, it's up to the police to determine whether or not they do have that vulnerability and require assistance with communication within a 6-hour period. Getting an appropriate adult or a social worker or someone who can help facilitate the information transfer between police, solicitor and the individual can take a lot of time, especially in remote and rural areas, especially if the scheme that is operated by the local authority isn't well resourced and you're requiring extraction from a social worker's day job or in the middle of the night. So that's something to consider too.
Yes, that look was consent.
Carry on.
Yes.
Thank you. Yes. If I can move to the second question I asked the first panel, I'll also ask this panel. Do you think that there's a missed opportunity here to tackle the UN Committee's rights of the child and raise the age of criminal responsibility to 12?
Yes.
Would you urge us to do so?
I would urge you to raise it because the government's already given a commitment to look at this. The issue is whether, as was raised previously, whether this is the bill to do it. But in the absence of any indication of another criminal justice bill, I think that it has to actually be raised, at least to get some clarity as to how the government are going to give effect to their commitment to raising the age of criminal responsibility, which I welcome.
I agree completely with what Tam Bailey has just said, and I draw the committee's attention to the commitment that the Scottish Government made in the Do the Right Thing Progress Report 2012 on its progress on advancing the rights of the child in the UNCRC, that it would give fresh consideration with a view to bringing forward any legislative change in the lifetime of this Parliament to raising the age of criminal responsibility. And as Tam Bailey says, in the absence of any other legislation that could do it in the lifetime of this Parliament, this seems like an entirely appropriate bill and will be in line with the commitment that the Scottish Government made in the Do the Right Thing Progress Report. In our experience as Bernardo's, we see situations where children and young people, children who are referred to children's hearings on offence grounds, accept the grounds, often because their parents say, just say aye, it'll save time, it'll get it sorted, not realising that by accepting the grounds or grounds being proven at a proof hearing, that child can end up with a criminal record which will appear in PVG checks in future, may bar them from certain professions, visiting certain countries, and that's a decision taken when a child is 8, 9, 10, 11, that will have potential consequences for the rest of their life. It doesn't happen that frequently, but we think it's a loophole that needs to be closed. It's a commitment that the Scottish Government make, and we think this bill is an excellent opportunity to close that loophole of a gap between an age of criminal prosecution of 12 and criminal responsibility at 8.
Would you accept the point raised by the previous panel, those who heard the previous panel, that it, while sympathetic as they were to the idea that it's a biggie, it's a really big thing to do in a bill at this stage, you know, where you'd have to go out to consultation, you'd have to have committee witnesses before you at stage 1. We are fourth panel, I think, you know, that to pop it in now in the middle of everything else, sympathetic though the previous panel were to it, and I'm not preempting how members of the committee might feel about it, that it would be too big a thing to plump in now. It might be in another bit of legislation.
In response to that, I would again highlight the commitment made in the Do the Right Thing Progress Report.
It's nothing to do with commitment, it's to do with...
by the Scottish Government, that it would give this consideration in the lifetime of this Parliament. Yeah. And the substantial change was delivered through the licensing bill, where the age of criminal prosecution was raised to 12. This, from our point of view, is a loophole that needs to be closed. The substantive
I'm not talking about
made.
principle, I'm talking about process. I mean, the thing one has to do, certainly government ought to do, and this committee certainly ought to do as well, is to really test these propositions, and whether we have, at this stage, the mechanics and the time, and now the government has, to test it thoroughly so we get it right. That's the only point I'm making to you, whether it would be appropriate at this stage. And given it was the evidence of the previous committee who felt, yes, quite sympathetic, but whether it could be done in here, are very...
I say that the Scottish Human Rights Commission evidence in the previous panel was very clear that this was absolutely the right vehicle for it.
Forgive me, it was the two professors who felt.
And I mean, I think the point is it's unfinished business. It's not a fresh piece. It is perhaps, maybe we can develop that, okay. It is unfinished business from the 2010 Act.
Fine, I misrepresented the Human Rights Commission, but two professors I certainly think were of the view that there was enough going on. Yes.
Given that we also have children and young persons bill going through, which is talking about GERFEC, which is talking about supporting young people, emphasis on the UNCRC. This is unfinished business. This isn't, as my colleague said, this isn't the major change. This is the leftover change. It would stop us having the youngest age of criminal responsibility in Europe, which I think is something to be ashamed of. And also, the sky has not fallen in other countries which do not criminalise the under-12s. We have other ways of dealing with it. Let's finish the job. We only did a half a job, not even a half a job. We did 3/4 of the job last time. This is the last bit. This is the perfect opportunity to do it.
Powerfully made. Anyone else wish to, before we...
The very least that the committee should be raising it through the report stage.
Well, I mean, we will. This will all be in the evidence session. There will be views in the committee about whether or not it's something that ought to be in or ought not to be in, or other issues. So no, certainly it's a good point to raise. I'm taking John Finney next, Liam, because he's not been in yet. Have you been in with a question in this session?
No, you're very kind, Convener. I would like to... Yeah, thank you very much. Panel, I'd like to go straight to Regulation 14, which is, I beg your pardon, 42, which is titled, and I quote, duty to consider child's best interests. And there's engagement between the public sector, the police and the local authorities, all of whom signed up to the GIRFIC principles with regard to joint investigations at the moment. Yet my understanding would be that notwithstanding great improvements, there is still a tension there between whose interests are being served and what objectives each side has to achieve. So when in subparagraph 2 it talks about in taking the decision, the constable must treat the need to safeguard and promote the well-being of the child as a primary consideration. That may, on one level, seem a laudable concern, but I'm sure many cops would say, my job's to investigate crime. And so my question is this twofold. A primary consideration, the Scottish Human Rights Commission say it should be the paramount consideration. And if you'd like to comment on that existing tension and how training, and I imagine there would be considerable training that would be required to address putting that in place for people, and as a representative, formerly a representative of police officers, as who would see their obligation as, I'm here to investigate the crime. Mr Bailey, perhaps.
Yes.
Firstly, I warmly welcome again best interest being in the face of this bill. And in fact, I would suggest that we should be consistent with the terminology, because best interest turns into well-being in subsection 2. I think it would be wise to have best interest in that section. And the other thing is that this has got a resonance with some of the debate which will be unfolding through the Children and Young People's Bill, of which best interest is going to become, in my estimation, one of the central things that we look at. I take the point. I think that we are asking a lot of our police. Best interest is quite challenging, but I think that this is a really good opportunity to make sure that we've got something in our legislation which again has got resonance within UNCRC. In terms of how police officers perceive their role, I think there's a...
Seeking to speak for police officers.
Oh, right, okay.
I was just giving...
Sorry.
The Highlands, though.
Okay, for Highland police officers. My perception is that, in fact, getting it right for every child is changing the way that our professions operate at a local level. And I think that the bill, as currently framed, will help progress that, help push that in a similar direction. I think many professions don't just see the roles as narrowly defined as being a police officer or a teacher or a social worker. I think they actually, in terms of our integrated approach to services, is beginning to change the way that people engage and see their role much more holistic and much more than just the narrow lens. They've still got a job of work to do, but it's a much shared, a much better shared responsibility. We still have a long way to go, but I am hopeful, and I think that the framing of legislation with the police having best interests of child as part of their responsibility will help that.
Usually, I may be wrong, with the welfare of the child. Is that not there, or is it switched now to best interests?
Well, what's happened is that you've got the Children and Young People's Bill that talks about the well-being of children and young people. We've got certain parts of our legislation that already talk about best interest. For instance, the 95 Scotland Act. Here we have best interest being introduced into this legislation, which I welcome. And I think we just need to try and bring some consistency to our application of the phrases that are used.
Seem to be several. Was it the welfare of the child previously?
It was, yeah, and welfare is very well understood. There's case law on it. We also have case law in best interest as well. So we're in a place just now where we should be considering how consistent we are in terms of those obligations.
Yeah, Mark Ballard, then more interesting.
I agree very strongly with everything that Tam Bailey has said about supporting seeing best interests on the face of the bill, on the challenge that there will be to police officers in making this transition. But again, as Tam Bailey has said, this is part of a wider transition driven by the Getting It Right for Every Child agenda. However, I agree with the points made by the convener and by Tam Bailey about well-being. And well-being, as defined in the Children and Young People Bill, is a multifaceted term which covers all the articles of the UNCRC. The more usual use, as the convener has pointed out, is that the best interests of the child are paramount, or the welfare of the child is paramount, and that's in accordance with what Article 3 of the UNCRC says. And there are rights that are in the different rights in the UNCRC, the different which are translated into the GERFEC wellbeing indicators may be in conflict. There may be a conflict between a right to privacy and the best interest of the child. Paramountcy is important to us in ensuring that the welfare is paramount over all other rights and other considerations. I'm uncertain how well-being, which is multifaceted, can be primary. I can see entirely how best interests, and as Tam Bailey has described, there's case law on how best interests can be treated as paramount, how the welfare of a child can be treated as a paramount consideration. I'm not sure well-being is the right term, and as has been pointed out, that the title of Section 42 is best interest. Best interest is not quite the same as well-being, and I think it would be more helpful for police officers, for consistency with things like the Children's Hearings Bill, if welfare or best interests were used as the primary consideration. But we fully support the principle that best interest should be on the face of the bill, and that GERFEC will require change, but we are seeing that change happening in police forces, particularly Highland Police Force, because Highland has been the pathfinder area for GERFEC.
More anxious.
Pathfinder for Highlands.
There's a great degree of unanimity here. I would endorse very much what has been said by both Tam and Mr. Ballard. Well-being is a difficult concept to define in a legal setting. Best interests and welfare have a long history and are well understood and are consistent across the legislation. I know the Faculty of Advocates has spoken very strongly about this, as does the Law Society of Scotland, in terms of the Children and Young People's Bill, and we need that consistency here as well. When it comes to young people who offend or who are dangerous to themselves and others, we already in the Children's Hearing Act allow for us to override the child's best interest, because it may not be in the child's best interests to go into secure accommodation, but it may be necessary in the interests of the safety of other people or themselves to go into secure accommodation. So when it comes to investigation, if the police are required to regard the best interests of the child as paramount, there may indeed be times when that needs to be overridden in the times where things are very dangerous or very extreme, which are mercifully very, very rare.
I understood that. For this time of the day, I understood that. It's not your fault. It might be you understand the explanations, yes.
Just add a point to this about best interest, because it's not clear to me from it's Section 14, the investigative liberation, as to whether in the exercise of that, the best interest of the child has to be taken into consideration. Now, it may be a drafting issue, it may be that I haven't quite understood it, but I can imagine circumstances where, for instance, the imposition of a curfew would have a very significant impact on a child's best interest. If they were, the thing that kept them off the street was the youth club that they went to, for instance, and that curfew cut across that. So I think it would be just worth seeking reassurance that best interest. My reading of it is the intention is that it ribbons its way right through every stage, but particularly in regard to investigative deliberation, that it was taken into account. And if it's not, then I would suggest that it should be, to be consistent with the other sections. Yeah.
And for clarification in terms of Bernardo's position on well-being, in the Children and Young People Bill, we believe that well-being is the appropriate term to use when planning children's services, which need to be done in the round for doing a needs assessment where you need to look at the breadth of needs that the child has. Our concern with well-being as a primary consideration, we think that there are situations where well-being in the Children and Young People Bill is the appropriate standard. We just don't see this as a situation where it's the appropriate terminology for the reasons discussed.
I can see a long debate at stage 1 drafting on that word. Can I thank you? I'm not going to say the usual thing, blinker myself here. Can I thank you very much for your evidence? Is there anything you want to add that we haven't asked? Mark Ballard.
I did want to highlight issues where children are affected by the justice system through parental imprisonment. There's evidence to show that up to a third of children are present when their parent is in prison.
But this is in the bill.
It isn't in the bill, but we'd like to see recognition in the bill that if Section 42 looks at children and young people and child's best interests, consideration should be given to the impact of imprisonment, detention and arrest on children and young people. And we'd like this to be something that the committee does think about as the bill goes forward.
Thank you for putting that on the record, yes.
In terms of Sam H's point of view about training, which is mentioned in the policy memorandum about support for vulnerable persons, the training specified, which will be dealt with in regulations, is very much about the appropriate adults. We think that there could be a missed opportunity not to ensure that police, who are the gatekeepers for support for people who are vulnerable, should be given appropriate training as well, because as my colleagues have discussed, it's very difficult sometimes to ascertain someone's vulnerability.
I think to give the police their due, in the past few years they've got a lot better at being subtle, the subtleties of some of the, certainly the autistic spectrum and so on. They do training in that, as I understand it.
I would agree with that, but looking at the custody sign-in sheet that someone would have, you're asked if you have a mental disorder or an illness, you're asked if you have ever attempted suicide.
We're happy with the phrase mental disorder, if I may say, on behalf of the country. We're totally content with that expression. So that would, I mean in the bill, so I think that would be reflected in any forms and so on. I think we're very happy with that so far. The evidence to date has certainly not made us happy with it.
Ms Stewart's point, not that it's not sufficient to give someone a form and ask them to identify whether they're vulnerable, that you're looking for much more in-depth training.
The questions that police ask someone when they're going into custody might not catch someone with a learning disability, because they might not say that they've got a disorder, and some people who have a mental health problem with a bad experience historically with the police might not want to disclose.
I think the point I was making is I think we're very happy with that expression anyway in the bill, generally speaking. Tam Bailey.
Yeah, it's just a point of clarity for the point that Mark made about children who are affected by parents who may be arrested or who may be detained. And in fact, this committee has considered a point of sentence. And if best interest of children is going to ribbon its way through the bill, it would be advisable to look at those sections where there's the arrest, detention and indeed investigative deliberation to take account of the best interest of children that may be affected by any of those decisions. I think that's the point of reference that you're looking for in terms of where it appears in the bill. It might not be a good
place to be sent back to home, or it might be a good place and take to extremes.
Yes, it cuts both ways.
Yes, yes.
Yeah. But as long as it's a consideration, then at least you've got it in there.
Thank you very much. Well, thank you very much for your evidence, and we're going to move on into private session, so I'd ask for the room to be cleared, please.